Good afternoon, good evening, good morning. We're so pleased that you're with us today. I'm Janice Kaminer-Resnick, and I'm delighted to welcome you on behalf of myself, former Congressman Mel Levine, and former Los Angeles County Supervisor Zev Yaroslavsky. That is our America at a Crossroads leadership team. A very special welcome back to tonight's guest, the amazing Linda Greenhouse. It's been 14 months since Linda was last with our audience, and we are grateful to learn again from you tonight. There's so much to talk about. Welcome as well to our wonderful moderator, Patt Morrison. Zev, Mel, and I wanted to take a moment at the top of this program to remember and pay tribute to David Lehrer, whose untimely passing 2 years ago we commemorate this week. Those of you who have been with America at a Crossroads for a long time know that David was a vital part of our small leadership team and a co-founder of this project. David was one of those rare people who did everything with thoughtfulness and integrity. He was a brilliant thinker, a passionate advocate, a gifted lawyer, a devoted father and husband, and a deeply loyal friend. He had a great sense of humor and a great sense of historical perspective. David was, just to put it mildly, an extraordinary human being. His sudden passing on October 25th, 2023 was a shock and a tragedy. But tonight we remember not only what was lost, but what David gave us. His intellect, his moral compass, and his vision. He also gave us the final minute of each of our shows when we ask our guests to leave our audience with something positive and optimistic. Since David's passing, with all that has happened in our country and around the world in the last 2 years, that has become increasingly challenging, but it is just one of the ways that David's spirit remains with us each and every week. David left behind a legacy that continues to shape our work every day. He was, above all, a mensch, and we miss him truly every single day. Now, just a quick note about our upcoming programs on October 29th, that's next week. Joyce Vance, who was a federal prosecutor turned legal commentator, will be with us. She's written a new book, and I think it'll be a great program. And the following week, we have an election scholar and democracy expert, Rick Hasson, coming back, a UCLA law professor. He has amazing things to teach us about the election processes and particularly what's going on with all of the gerrymandering around the country. You can register for these and all of our October, as well as all the rest of the year's program in the email that you'll get after tonight's program. There's only 7 programs remaining in 2025 after tonight. You can register for all of them, and we hope that you will. Thank you, as always, for your support of America at a Crossroads. We rely upon you, and we're grateful to you. Now, without further ado, please welcome tonight's outstanding moderator, Patt Morrison. Pat has a share of 2 Pulitzer Prizes for her work as a writer and a columnist for the Los Angeles Times. She's won 6 Emmys for her work in television and broadcasting, and she has won a dozen Golden Mike Awards for her work in radio and television in the public affairs domain. She's truly amazing, but most importantly to us is her work with America at a Crossroads. She is a vital member of our team, and we're grateful to her for that. Pat, the show is yours. Thank you.
Thank you, Janice. And again, a moment for a memory of David Lehrer, an extraordinary man who I had the privilege of knowing and interviewing, talking to, spending time with for more than 20 years. And so our hearts go out to his family and to the larger community to miss a man like this. So thank you all for joining us. And tonight is for David. Linda Greenhouse joins us for the second time. We're very happy to have her back, the Pulitzer Prize winning journalist and a senior research scholar who teaches as well at Yale Law School. She covered the Supreme Court for the New York Times for something like 30 years and still writes about it for the New York Times. The author of several books, including a biography of Justice Harry Blackmun. Linda, so happy to have you back.
I'm very glad to be here, although thinking back of these last 14 months since I was last here, who would have imagined what's been going on? It's just, it's mind-boggling.
Well, we'll try to catch up with some of that and your insights about the more recent news about the Supreme Court. 2,000 years ago, they said all roads led to Rome. Now it seems like all roads in this country lead to the Supreme Court. From every corner of the country comes some kind of case, some kind of appeal, a lot of it hinged on Donald Trump asserting authority unprecedented in this country. And it seems like ordinary Americans who would have maybe checked in on the Supreme Court every few months are now watching it on a regular basis in anticipation and sometimes in a little bit of trepidation about what's going on. So at one point here, we'll talk about the new cases coming up in the new session of the courts. But the Trump court, Donald Trump has a 6-3 majority on this court. We talked years and decades ago about the FDR court. Is the Trump court truly a Trump court in that sense, or has it gone beyond even the FDR parameters? Because FDR did get some pushback from that court.
Oh, yeah, no, FDR brought the court to heel, that is for sure. So this moment finds us in this very ambiguous situation because, as everybody knows, the court spent the summer basically ruling for Trump in case after case after case. But I use the word ruling in the a kind of popular sense, not in the technical sense, because in the technical sense, these weren't really rulings, they were orders that simply entered stays of lower court opinions. And so on one level, they were purely procedural, and you can't really draw a lot of lessons from them because the court did not favor us with explaining itself or giving any rationale. But of course, on the other level, these procedural, quote, rulings have had drastic real world effects. I mean, the court issued a stay of a lower court opinion that said that no, the president does not have the authority by executive order to dismantle the Department of Education. Congress created this cabinet department and only Congress can get rid of it. And the court issued a stay of that ruling pending appeal to the next highest court without any reason over vigorous dissents from the 3 remaining liberal justices. And so even though eventually the court might take that case on the merits and might see it otherwise, I don't think so, but theoretically, the department is basically gone, can't really be reanimated.
What do we lose when we don't understand the court's reasoning for something, or to hear any precedents, or really to lay out what did happen or what didn't happen apropos of the Constitution?
I think one thing we lose is a sense of the legitimacy of this enterprise, because really all the court has, I mean, judges only really have power that flows from the other branches and from the people being willing to do what the courts say they have to do. And the way the court persuades us that it is acting legitimately is it explains itself. And it tries to explain that it's not doing politics, to take a phrase that Elena Kagan has occasionally used, but that it's doing law. And only when it's doing law is it entitled to respect. But when it doesn't tell us why it's doing what it's doing, we don't know what to think.
We want to make sure that you who are watching know that you can put your questions in the Q&A box, and we'll try to get those to Linda in the last third of our program this evening. So go to the Q&A box. We'd like to see your name, your first name, and where you're from, and to put your question to Linda. Sometimes your questions get answered in the course of the conversation, so listen in, and that may happen. But is this disproportionate compared to other courts? How often this court just says thumbs up or thumbs down, back to the ancient Rome again, without telling us why?
It's highly disproportionate. Now, of course, at the threshold, what's disproportionate is the number of requests that the Trump administration has brought to the court. I mean, many, many, many more. I won't say they come up to the court whenever they lose, because sometimes their loss is so obviously merited that they don't bother. There's some lawyers in the administration that have some sense left. But basically, all the hot button stuff, can the president fire a commissioner of an independent agency just by saying you're fired, this kind of thing, that those have all come up. And so the court has had all this kind of raw material, and it has to say one thing or another, I think. Although interestingly, I'll digress for a minute, because I've been refreshing my browser every few minutes, and not few minutes, few hours, and maybe I've missed something. But there's a request by the Trump administration to the Supreme Court involving the deployment of the National Guard in Chicago. And the lower court, the Court of Appeals, said you can mobilize the National Guard, but you may not deploy it. And that's been on hold. And the hold expires tomorrow, the 23rd of October. Uh, and the request, the emergency request by the administration to put that, to issue a stay of that decision went to Justice Amy Coney Barrett. She's the so-called circuit justice for the Seventh Circuit, which includes Illinois. And typically, the circuit justice in an important case will refer it to the full court. So all the justices get a chance to weigh in collegially on collectively. She hasn't done that the last I checked. She's just been sitting on it. All the briefs are in. And so maybe she's just letting time run out, which would leave the Trump administration, of course, holding the bag. They cannot deploy these National Guard troops. So it's very fascinating. It's different, something
So
different.
tomorrow we should all start refreshing our browsers in that case.
Maybe, I mean, I was eating dinner. Maybe something happened in the last hour. I don't know. I'm on East Coast time. But it had not as of this afternoon. It's very interesting because if the court intervenes at this level with one of these so-called shadow docket orders on something as important as deploying troops against an American city in an American state, that's really crossing a kind of a threshold. And that's why I've been holding my breath, and I think a lot of court watchers are holding their breath.
And yet we have a Ninth Circuit Court of Appeals judge who has said that President Trump can go ahead and send troops to Portland. And this goes to our fractured federalist system, but it's kind of perplexing, but it goes to how many judges are in the federal system and how these decisions get how they wend their way through. As I was checking, I mean, it's World Series season, so we can talk about numbers here, that lower courts had handed Trump something like 80% of reversals, but he had won in the Supreme Court 19 times, and his last loss was in May. So there is this big gap between lower courts, appeals courts, and then finally the Supreme Court, some of which we haven't had revealed to us yet.
And of course, the lower courts are quite polarized. I mean, it's been fascinating to see judges appointed by Trump who have ruled against Trump. I mean, that's a very encouraging thing. There is still a rule of law, but the polarization showed itself in the Ninth Circuit that you mentioned. So the decision there was the decision to grant a stay of the lower court decision that said, no, you cannot deploy troops to Portland. And the Ninth Circuit set that aside by a vote of 2-1. So 2 Republican appointed judges and 1 Democratic appointed judge, Susan Graber, who wrote an amazing dissenting opinion, the last paragraph of which I should have it in front of me, but I don't. But the last sentence is what she said was, we're a panel of 3, and our larger court, there's something like 25 judges on the Ninth Circuit, and the sort of intermediate step is to be heard by a panel of 11, which she is calling for. This is not the end of the road. Our court has a chance to reconsider this. And so I asked those people in the country who are following this case to be patient and to retain their faith in the judicial system for just a little while longer. That's a federal judge speaking.
What do you think that meant? Like a little while longer until 2026, a little while longer until?
Well, I think she meant until the 11-member Ninth Circuit overturned. I mean, that's what she technically meant. But I think what she's saying in constructing a sentence like that, that's an amazing sentence to come from a federal judge. Keep the faith for a little while longer. She's saying that things are so bad that all we have to hang on to is the residue of faith that we were trained to have growing up as Americans in our judicial system, just hang on to it for a little while longer. I mean, maybe you're right. Maybe she means, until the end of the Trump administration, but it chilled me and it kind of brought tears to my eyes, actually, that we've come to that.
I want to get to the shadow docket and the rocket docket because we have a lot of questions about that. But I also would like to circle back and what you think it means when, what's going on the court that they are issuing these decisions, turning cases down without any comment at all. Are they ashamed, if I can even ascribe that? Are they concerned that they'll be perceived of acting extra constitutionally, even if though they're convinced they're not?
You mean their failure to explain themselves on the
Yeah.
shadow docket cases? That's what you're talking about? Um, I think it may be that, while there may be 6 votes to grant the stay that the Trump administration is requesting, there may not be a majority that has the same reason or that wants to go as far as others. And so the path of least resistance is just to issue the order and not say anything.
Hmm.
So, I mean, they get paid the big bucks to explain themselves, in my opinion. And if they have trouble hammering out a rationale that can command a majority, maybe there's something wrong with the rationale. But I think that's the reason.
What is, if there is a difference, we hear the phrase shadow docket and rocket docket. Is there a difference?
No, I mean, the kind of neutral word for the so-called shadow docket is the emergency docket. And every court has an emergency docket. They have to, if the emergencies come up. I mean, classically, in a capital punishment jurisdiction, a stay of execution would come up on the emergency docket. So, it's always been there. What's very unusual is using that emergency docket instead of just kind of in a housekeeping way to actually make law. I mean, for instance, the California case that came up on the shadow docket during the pandemic that had to do with the legitimacy of the state's order that no more than a handful of people could assemble in a household during the pandemic. And this was challenged by some people who held Bible study sessions in their homes. And they said this violates the free exercise of religion. Well, that's a big question. How do you balance religion and a public health emergency and, deep policy issues? And without granting full review in the case, the shadow docket, and it came, as I recall, it came down late at night. The court created a new rule of religious rights. The court announced, I mean, they wrote, this was not a case where they didn't say anything. They wrote an opinion that said that anytime religion is not treated as well as anything else, that violates the free exercise guarantee of the First Amendment. I mean, that's a major step. It's people call it the most favored nation clause for religion. Religion not only gets a seat at the table, it gets a seat at the head of the table. And that came up on the shadow docket. And just so people are clear, on the court's regular docket, so for instance, the court's going to hear a case this term on, or 2 cases actually on, in the area of the culture war over trans identity, um, about trans women playing sports, right? So the court has told us they're going to hear the case. Briefs are coming in. An argument date will be set, or maybe it has been set. The argument is a public session. You can't see it, but you can tune in for a live stream, as I do frequently, and then they'll issue an opinion. So, that takes months, but there's a transparency to it. The shadow docket just kind of pops up without transparency. That's really the difference.
I wonder whether, apart from the 6-3 division we see between conservatives and liberals, is there some tension within that conservative faction over the court, between those who want maybe narrower rulings, like John Roberts, who talked at his confirmation hearing, I think, about, calling balls and strikes, and other elements of the court that want broader authority, extending like immunity to Donald Trump for a great many of the things he's already done. Is there a tension in that faction of the court that goes to reputation, that goes to credibility of the court, and maybe other elements we don't even know about?
Yeah, I think there is some tension. I wouldn't make a whole lot of it because at the end of the day, they do seem to manage to hang together on these big cases. I mean, the immunity case was 6-3. Um, if you look back, I mean, you can certainly find instances, for instance, the Dobbs decision that overturned Roe against Wade 3 years ago. That was not 6-3. That was 5+1-3. And the one was John Roberts, who would not have gone as far as the Alito 5 did. He would not have overturned Roe. He just would have kind of disemboweled it, but it would be left kind of limping along. So that, that told us something, but at the end of the day, it didn't really matter because Alito had his 5 votes. So, they do see things in different shades, depending on the issue. But I think progressives have a tendency to kind of project onto a John Roberts or more recently an Amy Coney Barrett to think, oh, maybe we see some glimmers there. And, glimmers don't really get you there. So I don't hang my hat on that.
We see a lot, I mean, in the background of some of these justices, been a lot of deference to the executive, because some of them worked in the Department of Justice. And it's like, well, we need to be able to have an efficient government, which sometimes devolves to an executive tilted government. But where is the pushback on separation of powers? Congress, as we see, has been, should we say, supine about that, this Congress. But the courts themselves, have they handed over any power? And is it just because it's this president that it looks like there's more of that? Or is that just the way this court is constituted and would do the same for any Republican president?
Or even maybe for any president. It's there's a belief on the conservative side of the street, and it's not new, and it's not driven by Trump. It's not really driven by the party of the incumbent in the White House, but it's a belief that the Constitution, Article 2 of the Constitution, which set up the presidency, intended the president to have unitary control of the executive branch, that the president personifies the executive branch. The president is the executive branch, and everything else is just window dressing. And so there's been tension, I mean, for decades, going back to the New Deal period, which is now, of course, almost closing in on a century ago, when the quasi-independent agencies were set up, the Securities and Exchange Commission, the Federal Trade Commission, where the commissioners of these commissions were given terms of years, and the president was told, you can fire these people only for cause. Didn't really define cause, but only, you can't just say you're off the island. That's been a source of tension. And what we have now are 6 members of the court, as it happens, who really subscribe to the unitary executive theory. And so the court will hear 2 cases in the term that began a few weeks ago about how far that extends and to what extent did Congress trench upon the president's constitutional powers when it created these agencies and gave these protections to the individuals who sit on those commissions. And it's very important as a structural matter as to how we govern ourselves. It's kind of core stuff.
It seems that some of the decisions, you can almost conclude that, well, Congress did its job by creating the agencies, and now everything else is up to the executive. Is that a fair?
And where is Congress? And so the separation of powers contemplates that there are three branches. And of course, it didn't contemplate that there were, to say separation of powers, it didn't contemplate to say each one is totally in a separate silo. I think the framers contemplated um, an exchange, a dynamic interchange among the three branches that collectively make up our government. Uh, so what happens when one of these branches, Congress, just lies down and rolls over? And so there's something profoundly out of whack in our system right now, profoundly. And there's really no way of sort of forcing it back except at the polls. And then you get into the whole problem of, the safe seats and the two senators for every state and the structural obstacles to creating a Congress whose membership really reflects the will of the people.
But wouldn't the Supreme Court, by saying no to some of the perceived overstepping that Trump is doing apropos of agencies Congress created, essentially be giving Congress a kick in the pants saying, go back and do your jobs?
Yes, I mean, that's true. I mean, for many years it was thought that, it didn't matter all that much if the court um, misinterpreted an act of Congress because Congress could always fix it, unless it was a constitutional holding. But, if it was just, if the court got something wrong about a statute, send it back to Congress. But, in recent years, Congress has been unable to get its act together and, pass anything. So theoretically, you're absolutely right. But as a practical matter, that just isn't happening.
Um, Over the past decades, there have been conservative justices who have changed their position, who've moved toward the center. You saw impeach Earl Warren signs coming from Republicans about a Republican appointee by a Republican president because they didn't like his rulings on integration, among others. But is there any chance of seeing that happen on this court among these conservatives, or is this a new kind of conservative?
Yeah, I don't think there is a chance. These people were all very carefully vetted and kind of validated by interest groups on the right. Um, they all sort of cut their eye teeth in the culture wars, you might say. Unlike the Republican appointed justices of the maybe not too recent past. Earl Warren was a long time ago, but Eisenhower chose Earl Warren to be Chief Justice, not for ideological reasons, but to get him out of Republican politics. He was three-time governor of California. He'd never been any kind of judge. And Eisenhower just wanted to sort of disable him by parking him on the Supreme Court. And other Republican appointed justices who were chosen for one reason or another and came from the boondocks, you might say, had not played the political game inside the Beltway. You come to Washington in midlife, it kind of shakes you up a little bit, maybe opens your mind to some new way of thinking. I mean, that certainly applies, I think, to Sandra Day O'Connor, to Justice Anthony Kennedy, to Justice Harry Blackmun. None of them were Washington insiders, but the crowd today, I mean, Sam Alito never cashed a paycheck that wasn't issued by the federal government. Um, Neil Gorsuch, even though he was a judge in Colorado and is a person of the West, you might say, he grew up in Washington. He and Brett Kavanaugh went to the same Catholic boys prep school in the Washington suburbs. And so uh, I think what we see of these people is what we get. I mean, the one exception, of course, is Amy Barrett. She was not a Washington person. She was a law professor. She's very interesting, but um, but I don't think she shows much signs of an ideological revolution in her mind.
The phrase of court reform comes up every time you have a court you don't like, meaning people don't like And just today, I think I saw a poll by the Public Religion Research Institute that they supported term limits. 67% of Republicans in this poll supported term limits, which is a convoluted, maybe an impossible process. So, but it says a lot about some doubts, impatience, concerns about a perpetually instituted court.
Well, that's true. And I think, term limits would be nice, I think. Uh, but, the US Constitution is the hardest constitution in the world to amend. And the I think the better understanding of the life tenure situation is that it's hardwired into the Constitution. There are people who have made some very smart people have made suggestions for ways to work around it, have kind of grow the court and have the old justices do other things other than ruling on ruling on cases. But I don't think that really flies. And furthermore, if you instituted term limits tomorrow, and presumably it couldn't apply to the incumbents, and so it would only be prospective. Um, some number I read a few months ago said that you would not actually change the membership of the court until 2047.
Oh my goodness.
Yeah, yeah.
Because the process is so convoluted and nigh on to
Well, because
impossible.
the incumbents would stay a long time. I mean, the people the three who Trump put on the court are pretty young as justices go. They're in their 50s, I guess. And so they could be there for another 30 years.
Before I start getting to some terrific questions, any chance that any of the conservative justices would retire while the older ones, while there's a Republican president and a Congress that would approve his choices?
I do not know. It would be very presumptuous of me to pretend to know the answer to that.
Let's see who we've got calling here. Let's see. Ruth wants to know, and this is a question that comes up again and again about the courts, as you know, whether the justices, particularly those in the majority, care that the American people are losing faith in them. And there is a Gallup number showing that the Supreme Court approval rating is down from 62% 20 years ago to 42% now. So it's not just an imaginary concept.
Yeah, so I mean that's true. And the question is, do they care? And the further question is, even assuming they cared, is that going to lead them to change their stripes, right? And I don't actually think so. I don't see any evidence of that because, uh, hard as it may be for some people on this call to believe, they really think they're doing the right thing, and they have a different view of the law and the Constitution than many of us gathered here today have. And I think we have to recognize that. I think some of them really believe and came of age believing that starting maybe in the 1930s, the country just got on the wrong track in terms of the meaning of the Constitution and the role of the various elements of our government. And that's their belief, and they think they have the duty, the responsibility to get it back on the track that they think it should be on, whether the public opinion polls support that or not. So I think that's just reality.
It would mean retracting what people have long regarded as rights, like abortion, as we saw with Dobbs. It's a tricky one to pull off.
That's right. They pulled it off by a series of tricks. But yeah, and they've paid a price, definitely, in terms of public approval of the court, which plummeted and has not rebounded after Dobbs, which is very unusual. I mean, political science about the court tells us that over a not too long period of time, even a controversial decision that a lot of people don't like, people kind of figure, well, the court has ruled and, let's move on. That hasn't happened with Dobbs.
Hmm.
Court has not, public approval has not rebounded. But the people who voted the way they voted in Dobbs, thought they were doing the right thing, thought they were doing something they had to do. Maybe God told them they had to do that. I think it's true of some of them. And so they're not going to be deterred by what people think.
Stephen wants to know whether you think that Section 2 of the Voting Rights Act is about to be obliterated. We've seen it chipped away and chipped away by this Roberts Court already.
Yeah, so that's a very good question that relates to the Louisiana case that was heard last week. And my tentative answer is um, they're not going to flat out overturn Section 2 of the Voting Rights Act, which is the section that requires that when there's a minority group that is defined and cohesive enough to theoretically elect a representative of its choice, it has to be given that opportunity. What I think they're going to do is keep Section 2 alive, but cut the heart out under it and in a way, weaponize it. And what I mean by that, the argument took, to my way of thinking, maybe I just wasn't prepared enough, but I was very surprised to the point of being shocked at the turn the argument took, which had to do with politics. And so what the lawyers arguing for the Trump administration and for the state of Louisiana were saying is, okay, a few years ago, the court ruled in a case called Rucho that political gerrymandering for political purposes was outside the jurisdiction of the federal courts, that the court wasn't going to get into it. It just was a thing. And the courts could not have a kind of a metric to be able to ascertain how much political gerrymandering is too much. And so we're just not going to get into it. Okay, that was a case about the jurisdiction of the federal courts. Now, that case, Rucho, R-U-C-H-O, is being used in the Section 2 voting rights area to say, okay, if you're gerrymandering for politics, that trumps, I hate to use that word as a verb, but that trumps the racial considerations, that trumps the racial equality that is demanded by the Voting Rights Act, because the Supreme Court has told us that political gerrymandering is completely okay.
So the states can say, oh, no, it's not racial gerrymandering, it's political gerrymandering.
Yes, yes. And what shocked me about it was I read the Rucho decision as a decision about jurisdiction. You know, we, the justices, are hands off. Not that gerrymandering is okay. The court said it's a bad thing, but we just can't get into it. And now it's being put forward as an affirmatively good thing that we can use our politics to do this. And so if you had a Republican legislature, let's posit in Louisiana, I don't know if this is true, but let's posit a Republican legislature, 6 congressional districts, 2 of which are currently represented by Black representatives. And the Republicans say, you know, we want to have all 6. And it has nothing to do with race. We just want to have all 6 Republicans, and that's fine. And so we're just going to redistrict and carve up the minority communities in such a way that Republicans are going to win in all 6. And according to the argument that I heard last week, that's perfectly okay. And if the court says that, which I think they might, that's a very bad thing.
That's the case, isn't it? Louisiana versus Calais that was punted from last session, that in the map, even though the state has a third Black population, only one of the 6 congressional districts would be a majority Black district. Is that the same one?
That's the case. Yeah, that's the case.
So all they have to do is like rebrand the reasoning behind the redistricting, and that sounds like it would fly with this court.
Well, I mean, that was the implication of the argument, so that, you know, people would see there's still such a thing as Section 2 of the Voting Rights Act. Aha, the court didn't get rid of it, but they will have turned it into something that it wasn't, which is, as I say, you know, weaponize it. And of course, there's always been tension in this area because racial racialized voting is identifiable politically, right? I mean, Black communities, maybe not so much in 2024, but over time are identified with Democratic majorities. And certainly in the South, whites vote for Republicans. And so there's been a kind of a melding, a merging of racial identity and political identity. But under the classic understanding of the Voting Rights Act, when it comes down to out and out racial discrimination or a discriminatory effect, race wins. I mean, you have to deal with the racial inequality. And this would take that out of the picture. I think if I understand the dynamic that was going on in the courtroom.
Jim and several others have the same question, which about whether the requests being submitted to the court by Trump are really valid issues for the court. If they're not emergencies, and whether or not Trump is taking cases just to take cases to win, and that the court is maybe overreaching by agreeing to look at these cases.
Yes, there's a lot to that. And the three dissenters often have said, this is not an emergency. Let the the appeal course run its course. Take it to the Court of Appeals and let's see what happens before we weigh in with a supposedly procedural order that has these lasting effects. So that's quite right.
Bruce wants to know whether you think what would happen if the court of Trump decides to run for a third term.
Ah, um, I I don't think he would get away with it. And we have a constitutional amendment on the books. Um, I don't understand what the argument could possibly be. Um, of course, one question is, would the court deem that to be justiciable, or would that be deemed a political question? So I'm not 100% sure that I know the answer to that, but I think I I can't see that happening. Maybe I'm projecting my own view of that, but
there's a lot that I think we hadn't anticipated that has happened in the last few years, or in the last 10 months, if you want to put it that way. Sandy says the current effort by President Trump to recover money he thinks he's owed because he was prosecuted and the case was not resolved. Does this violate the emoluments clause, apart from the fact that he's in charge of both pockets, that one he intends to pay and the other he intends to put money into?
I certainly would like to think it violates something. I mean, I was just astonished. I mean, I'm as surprised as anybody on this call. I don't really have any great insight into it, but it just seems weird, unethical, astonishing. It's not that he was acquitted in any of these cases. He just ran the calendar out, right? So in none of these instances did he get a clean bill of health. And so I don't get it, but I gather there's no one who's going to tell him no. So I don't know.
We were speaking about the constitutional amendment limiting presidents to 2 terms, and Linda and Lisa want to know about originalism, saying that even some originalist legal experts are questioning some of this court's opinion. Do you think any of this has an impact on the court? And don't you think the originalism is the opposite of what founders intended? Or there's your argument for 200 years, wanted openness to progress and to accommodate how the country was changing. We don't expect you to do 200 years of legal argument in a couple of minutes, but originalism has an elasticity now.
There's nothing original about originalism. Let's just put it that way. The framers certainly did not expect that, everything they did was going to be, engraved in stone. The notion of originalism was made up in the 1970s by the same people who later brought us Project 2025. So how's that working out? It was made up to find a a hook to persuade the public that the court was on the wrong course and had to be brought back. Because, you ask a person on a street corner, do you think the Constitution should be interpreted according to its original meaning? And people say, sure, we don't want judges just yanking ideas out of the blue. Um, so there are conservative scholars, as I think your questioner is aware, who have started to express some doubts about this, and maybe that'll grow. Um, the current court is not a totally originalist court. John Roberts doesn't call himself an originalist. I'm not, maybe Amy Barrett does. Um, but it's some of it may be up for grabs. We'll see.
When you and I were talking about the Trump claim that he's owed $230 million by the federal government, and we're discussing whether or not there could be some standing. Do taxpayers have any standing to go to court since it's their money? And you said no, not for many years have taxpayers had any standing that could accommodate something like this. And that kind of took me aback.
Yeah, no, we don't have a concept of taxpayer standing. So no, there has to be, if somebody's going to challenge this, there has to be some other kind of hook, and I'm not offhand sure what it is. Now, of course, you could imagine a Congress who would deem that an impeachable offense for a president to declare that, you know, his Justice Department should pay him this money. But we don't have a Congress that's going to go that route. I think that would be the answer to it if that was the judgment of Congress that this was something wildly inappropriate was taking place.
Of the cases that are coming up with the court this session, apart from the one we discussed, the Louisiana redistricting case, is there one that catches your attention that you think has real significance? A great many do, I'm sure.
Well, actually, not a great many. A lot of what the court does is kind of, not neither here nor there. But yeah, I mean, there's a pair of cases that have to do with the separation of powers that we started talking about, the president's authority over the independent agencies. So there's one from a member of the Federal Trade Commission who was fired, and then the other from a more prominent case that people probably heard of, a governor of the Federal Reserve who was fired. And the court has suggested in one of its shadow docket orders that the Federal Reserve is special, but it didn't say why. It didn't say what was special about it. So both of these cases are going to be heard, one in December, one in January. And that's a big deal because there was an old precedent from the 1930s, a case called Humphrey's Executor, that upholds the independent standing of these independent agencies. And the court is being asked to overturn that precedent. And I think it quite likely will. Whether it carves out a Federal Reserve exception, and if so, how does it explain it? I don't know. But that's a big governance deal, actually.
Does the court have any obligation to explain anything when it hands down a decision, as we've seen not happen in these shadow dockets? Does it ever need to explain itself?
Well, it thinks it does, yes. I mean, when it takes a case on the merits, when it's going to hear argument and, it takes briefs from, basically whoever wants to file a brief, and we all listen to the argument and so on, it will explain itself. Yeah.
There are two cases, you mentioned them before, that have to do with trans women trans women in sports, and also a Colorado case about conversion therapy, which has to go to free speech, whether people can talk about this, whether mental health therapists can talk about it, and is there such a thing as I think, a certified therapist in this category. Two cases on similar subjects. Is that very usual for a court to take on in one session?
Well, it's the court has injected itself into the culture wars. And so it's somewhat unusual, but it's kind of predictable for this court, and it'll be very interesting because, of course, back maybe 4 or 5 years ago, the court kind of surprisingly interpreted the Civil Rights Act, Title VII of the Civil Rights Act of 1964, to protect LGBT and trans people from employment discrimination. Now, that was a case of, excuse me, statutory interpretation, interpreting the reach of the Civil Rights Act. That didn't say anything about the Constitution. Um, so that was a kind of a toe in the water, and whether they're going to how the constitutional issues are going to affect are going to relate back to that statutory decision. We'll see, but it is a little overweighted in that direction because that's issues the court seems to care about.
Joyce Taken and several others want to know whether you think or how you think the court or whether it will even undertake questions of birthright citizenship and same-sex marriage.
Okay, so birthright citizenship, I think I'm very confident in believing that the court is not going to do anything to undermine birthright citizenship. It's going to declare Trump's executive order invalid. I think it's pretty clear. And I do not believe the court's going to overturn Obergefell, which was the 2015 decision that gave a constitutional right to same-sex marriage. What the court is doing, and I'm sure will keep doing, is finding various religious carve-outs for people who don't like same-sex marriage. So a term ago, there was the wedding web designer who wouldn't design, and then there's, the baker who wouldn't bake, and all this stuff.
For gay marriages.
Yeah, and it's all kind of symbolic. But at the end of the day, these marriages are gonna stand, and Obergefell is gonna stand as an opinion.
There's also a case coming to the court about tariffs, whether Trump has the power to impose unlimited tariffs at will. And again, does this go to foreign affairs, which is pretty much clearly an executive authority, I think, under the Constitution, or is this something else?
Oh, it's a great case. It's got everything. So at the first instance, it's a matter of statutory interpretation. Trump was claiming there's a federal statute that gives him this authority, but the appeals court, the Court of Appeals for the Federal Circuit, said actually no. This law doesn't mention tariffs. It doesn't give the president that authority. That's for Congress. So matter of statute. And there's all kinds of ways that Trump can and should lose this case. And I think he will. I think the argument it's November 5th, going to be very interesting because for the conservative justices who believe in interpreting statutes as they're written, they're going to have a hard time finding room for letting Trump do what he wants to do with this.
Mina has a question, and boy, does she boil it down. Does Roberts control the court, or does the court majority control Roberts?
Roberts doesn't control the court. No. I
Did he
don't
ever?
think there's a real center of gravity in terms of one person in the court right now. Um, I don't get a sense of firm leadership. I think their interests align because they, in the big picture see things the same way, but I don't think I don't see a whole lot of leadership emanating from the Chief Justice.
This one kind of boggled me when I read the Supreme Court's going to consider a case whether people who regularly smoke marijuana can legally own guns. Now, this is a court that has been expanding gun rights consistently, and it really struck me that, they have allowed, for example, people who have domestic violence convictions and who have served their time to own guns, but I've never heard a case like this argued about marijuana, nor about alcoholism for that matter. This is a curious one, at least to an outsider like me.
Well, it's not marijuana per se, it's drugs. Um, that's the statute that disables uh, somebody with a drug conviction from owning a gun. That was what Hunter Biden was convicted of, I believe, gun possession having had a drug conviction. So, um, the court has very widely enhanced gun rights, but actually they stopped short in the domestic violence one. They did not actually. Um, uh,
Oh, did not restore the rights then?
no, they
Oh,
did.
okay, good. Thank you.
They had to wiggle their way out of it, but they did. They granted this case because the lower court, the Fifth Circuit, had had found the statutory prohibition unconstitutional, and it actually was the Trump administration brought the appeal to the Supreme Court in defense of the statutory prohibition. So it's kind of interesting.
Another one worth watching. And very quickly, before we wrap this up with your positive point, Michaeline wants to know what the lower courts may be thinking of having so many of their decisions apropos of Trump overturned so often, because the statistics are the reverse. Trump wins very often in the Supreme Court and not nearly so much in the lower federal courts.
So what do the judges think about this? Um, on a certain level, kind of that's life. But what judges are really upset about right now are threats to their physical safety.
Mm.
And I've talked to a number of judges about this, and the kind of language that emanates from the president and the people around him, like Stephen Miller. Anytime they lose a case, they denounce a judge, even a judge that they appointed, in the most violent terms. And the judges are truly alarmed. I mean, they're scared, and so I think that's what they care about right now. Yeah, they'd like to be upheld for everything they do, but they don't want to be shot in the process.
That's a new element of menace that I don't recall having heard of in the courts before.
No, never, never. This is very bad.
Uh, of course, as you heard, we like to, in David Lehrer's memory, always end on something positive. So maybe you can give us something on the horizon, or maybe something closer right in front of us that we can take away this evening and think more hopefully about.
Well, I guess I would rest on the observation, Pat, that you made early in our time together. People are paying attention to the court, and that's really something different. And, it's always been troubling to me that people don't pay attention to the court, but now they are. And I think maybe they're going to keep paying attention. And even if they can't do anything to make the court, kind of come to where they like it to be, they realize that, ultimately the court is a part of our political process, and they're not going to look away again. I think that's a good thing.
Have you anecdotally seen that more people will engage with you, like, oh, and buttonhole you, or please tell me about why this happened, than might have
Yes,
been doing before?
totally. Yes. I mean, even I've spoken at some colleges and universities, and students typically aren't paying attention to the Supreme Court, but now they are, and that's a good thing.
Well, Linda Greenhouse, I hope we can have you back again, because there's always not only attention to the court, but a lot of meat to talk about what the court is doing in this session and elsewhere. So, Linda, thank you so much. It's always a pleasure for me to talk to you, and we welcome you, as always, to this forum. Thank you for joining us.
Thanks for having me.
We want to thank all of you for joining us today as well. Next week, you see, I'll be talking with Joyce Vance about the American justice system, testing the limits. The week after that, the great Rick Hasen with the great Larry Mantle. A number of programs taking us through the end of the year as we find out still what's going on in our government and try to make sense of it all. Thank you so much for listening and for supporting these vital programs.